the tender freeze, it's even stronger now that we're sitting in a position where the Director General would rather have all new business grind to a halt.
National Treasury has issued an order to freeze new tenders. Why is this? Well, joining me to discuss is Gabriel Crouse. He is the head of campaigns at the Institute of Race Relations. So, Gabriel, this action comes in the wake of a constitutional court judgment, which we at the CRA covered last week, involving the business group Sakeliga, which challenged some of the regulations around preferential procurement that were issued by the then Finance Minister, Pravin Gordhan. Fast forward 5 years later to 2022, and we now have this judgment. Treasury has now responded by issuing this tender freeze. Could you explain why they have done so, and also some more background to this case that I mentioned?
Sure, David. Thank you so much. So as you covered well, last week, BEE had an important pillar knocked out from under it. And that was the Constitutional Court's judgment that the 2017 Treasury regulations, which created pre-qualification criteria on race-based grounds. In other words, businesses weren't even allowed to begin to tender, to bid to do government business. Those regulations were struck down by the Supreme Court of Appeal. The Supreme Court of Appeal said, amongst other things, the minister can't do that. And then the matter was taken to the Constitutional Court, and the Constitutional Court agreed with the Supreme Court of Appeal, said the minister can't do that. However, there is a question mark about when the implementation of the court's order applies. So the Supreme Court of Appeal said these regulations are unconstitutional and invalid, so they can't stand. But we will allow them to actually remain in place for 12 months so that the ministry and parliament and whomever can get their act together to fill whatever gap might be created by striking down the regulations. That 12-month period lapsed at the end of last year. The Constitutional Court has then said the Supreme Court of Appeal's judgment stands, the appeal against it is dismissed with costs. And so on a plain reading of the matter, that seems to indicate quite clearly, in fact, that the regulations have been struck down, that the suspension of that strike down has expired, and that business needs to go ahead without those regulations. However, and here comes the big but, Treasury is arguing that the Constitutional Court's judgment actually reinitiates the 12-month suspension period, which effectively means the regulations, the pre-qualification race-based criteria, those regs stay in place until March 2023. I don't see how that argument works legally, but that's the argument that they're making. And they're saying until the court tells them otherwise, they need some clarification. Are the regs still in place or not? And until that happens, they're going to ask all organs of state to issue no new tenders, effectively grinding an essential part of government business to halt.
All right, so Gabriel, the Director General in Treasury, Dondo Mokhajane, he has indicated that there will be the freezing of new tenders. No new tenders will be advertised. This is going to have quite an impact on service delivery, is it not?
It is. We are currently trying to figure out exactly how much business this is going to disrupt. At the Institute of Race Relations, I wrote to the minister yesterday to request any cost analysis, how many tenders are going to be frozen, how many tenders from February 16th have been held in abeyance, and what is the cost estimated to be in terms of delays in implementing those tenders. So far, we haven't gotten a reply. We expect a reply within a week. In other words, I wish I could give you hard numbers. The people in the best position to give those numbers, we're waiting on what they have to say. But the simple point is this can't be in the national interest. And the minister is empowered for exactly a circumstance such as this, to grant exemptions to organs of state from particular race-based criteria, factors in procurement, to just go ahead with the most cost-effective bid. That exemption power is granted in the Procurement Framework Act for circumstances where it serves the national interest. Now, the question that stands before Minister Enoch Godongwana is what serves the national interest best? Granting that they are not sure about what the Concourt allows insofar as these specific regulations. The one option is to freeze all new tenders until they find that out, and who knows how long that might be. The other option is to say, well, because we're not sure, we're going to grant exemption to all organs of state from these race-based preferencing for tenders that are currently being issued until we find out from the Constitutional Court what the order is. If the order is, as it clearly seems to be, that the 2017 regulations are unconstitutional and invalid, then the exemption could continue on the basis that not just that regulation, but all Treasury regulations within the Framework Act are ultra vires, are, that is to say, beyond the minister's powers to create. That is what the judgment seems to say. Furthermore, the argument goes that it's in the national interest to grant these exemptions because the Zondo Commission said very clearly that there is a terrible tension in our legal system when it comes to procurement. On the one hand, the Constitution demands that the most cost-effective tender is awarded. And on the other hand, there is this interest in transformation. And the Zondo Commission found that the primary national interest is served by getting the maximum value for money. And that's pretty much a direct quote from page 797 on part 1 of the Zondo Commission report. The point there is the national interest is served by granting these exemptions. The Framework Act allows the minister to exercise that power to grant exemptions. And if that argument was strong before the tender freeze, it's even stronger now that we're sitting in a position where the Director General would rather have all new business grind to a halt.
So, Gabriel, is it correct to say that the government's ideological commitment to race-based policy is superseding or trumping the need for the state to deliver services to the public at a most cost-effective way and a most efficient way? What does this tell us about the ideological inclinations of the government?
I think that is fair to say. Let me qualify this first by just emphasizing that it's not the government's argument that they have to freeze all tenders because the only alternative would be to drop all race-based policy. There are other aspects of race-based policy in play here, but their position does seem to amount to saying that we as Treasury want to keep in the pre-qualification race-based criteria so that businesses can't even begin to bid if they don't have enough BEE points. We want to keep that in. We've been told we can't buy the SEA. We've been told we can't buy the Constitutional Court. We'd still like to keep it in for another year. In the intervening period of that year, acts like the Employment Equity Amendment Bill would come into place, which would reintroduce that factor, nevertheless. So we really want to keep it. And if we can't, or while we can't, we are going to shut down all new tenders in the hopes that what we will get is the result that we're looking for. That does seem to put ideology over and above the national interest. It seems extremely reckless to me. I have been reaching out to legal experts to try and understand if I am missing something here. Certainly, the feedback that I've gotten is that for all intents and purposes, Treasury seems to be holding the country to ransom in the hopes of getting the outcome it's looking for ideologically. And I think that South Africans should be concerned by that. I don't know that people should be particularly surprised by it. At the moment, I think the important thing to try and do is find a solution that is practical and effective. And until the Constitutional Court resolves the matter of what its order means, the simple solution would be for the minister to use his power to offer exemptions so that business can continue. And that's where we're applying pressure.
Gabriel Crouse, thank you very much. A quick announcement that we at the CRA are delighted that we have hit the 30,000 subscriber mark. So thank you very much to all of our subscribers for joining us. We look forward to providing more of our weekday analysis for you to help you make sense of this volatile environment in South Africa. In recognition of our 30,000 subscriber milestone, we are introducing paid memberships to the channel. There is more information in the description below, but that is competitively priced. Under 100 Rand will get you access to our monthly exclusive client webinars. So do sign up for that. My name is David Ansara. This is the CRA. Until next time, take care.